Interesting.
It is.
So, ladies and gentlemen, we're going to get started with the third and final panel at the law school portion of the symposium before we transition to the School of Social Work. It is my distinct honor now to introduce the third moderator for today, Corey Johnson, Esquire. Corey Johnson is currently the South Regional Director for the Reform Alliance, where she directs South States campaign operations aimed at developing solutions to transform probation and parole and dramatically reduce the number of people trapped within the criminal justice system. A Baltimore native, Corey is a graduate of Towson University and Howard University School of Law. Please welcome Corey Johnson, our last moderator for the law school portion today.
Thank you so much. I'm super excited to be here and to be moderating this panel, specifically because I think it's very important for us to understand the intersection between social work and mental health and behavioral health, which is we often don't have very many conversations about. Before jumping into our panel that's geared towards intervention specifically on the social level in very individual styles of our lives, I wanted to give a little bit about my own background. So I went to Howard Law, thought that I was going to be a criminal justice champion at Howard. Any Howard grads here, HU? Okay, awesome. That makes me happy. So, me particularly being able to be a social justice champion, I started working at the Department of Justice after law school, and I was working as an attorney advisor at the Department of Justice, specifically in the immigration division. So I was writing immigration decisions for federal immigration judges. And we got in a lot of asylum cases, and what I noticed was a trend. How many people know that if a person has 3 DUIs, they cannot receive asylum in the state of Maryland? Right. Okay, so that goes against your good moral character under the law. And I just couldn't believe it. So I called my mom crying. I'm like, I can't do this anymore. And I realized that one of the issues that is significantly impacting behavioral health are the public policies that are on the books. And so that led me into my, public policy, finding the intersection. And now I'm at Reform Alliance, where we deal specifically with individuals that are on parole and probation, individuals that are on parole or probation, and challenging inequitable circumstances that are impacting them on a policy level. And with that, I will go into some of our panelists and their backgrounds. We will start with Linda Jean Mack. Linda is a PhD student at the School of Social Work, University of Maryland, Baltimore. Prior to becoming a doctoral student, Ms. Mack worked in the child welfare system for over a decade in Massachusetts. Most recently, she was the director of a foster care program that worked to return children to their families or find placement alternatives when that was not possible. In addition, Ms. Mack was a community mental health therapist specializing in therapy for individuals and families impacted by family separation and adoption, and she continues to consult and lead trainings for mental health providers and social workers in the practice area. Ms. Mack has also been an adjunct lecturer teaching social work and human service skills for several years. Now a full-time PhD student, her research interests include the impact of social and child welfare policies on the experiences of all stakeholders involved in the child welfare system and preventing family separations and reuniting families when possible. The second panelist we have is Chaz Arnett, who is an associate professor of law at the University of Maryland School of Law. Professor Arnett holds expertise in the areas of criminal procedure, race and technology, juvenile law, and education law. His research explores the interplay between race, digital technology, and criminal legal processes. His scholarship offers critical legal frameworks in challenging purportedly race-neutral laws and technologies. Professor Arnett's most recent work focuses on examining the role that surveillance technology plays in perpetuating racial inequities through policing and corrections, which is really imperative to Baltimore. He is an affiliate of the Center for Critical Race and Digital Studies and a faculty fellow at Data and Society. Prior to joining the University of Maryland School of Law faculty, he was an assistant professor of law at the University of Pittsburgh School of Law, where he was designated as a distinguished public interest professor for his commitment to furthering social justice in his teaching, scholarship, and service. Before teaching, Professor Arnett served as a trial attorney with the public defender's offices in Baltimore and New Orleans, and as a staff attorney with the Advancement Project, where he assisted in local and national campaigns aimed at combating the school-to-prison pipeline. As a recipient of the Satter Human Rights Fellowship, he also worked with the International Center for Transitional Justice on issues of constitutional development in Zimbabwe and asylum cases for Zimbabwean refugees in South Africa. He has received numerous awards and accolades for his commitment towards furthering human rights through criminal law work. Additionally, we have Lori Graham, who is an MSW and PhD assistant professor at the University of Maryland School of Social Work. Dr. Graham is an assistant professor at the University of Maryland School of Social Work. Informed by her community-based practice experience, Dr. Graham's research focuses on sexual and intimate partner violence and fatality prevention. She employs a healing center intersectional lens to address violence prevention and is interested in the participatory development, implementation, and evaluation of programs and policies that seek to prevent multiple forms of violent behavior. She received her Master of Social Work and PhD in Social Work from the University of North Carolina at Chapel Hill, where she was a Caroline H. and Thomas S. Royster Fellow and Injury and Violence Prevention Fellow. Finally, we have Iris Cardenas. Am I saying that properly? Okay, awesome. Who is an assistant professor at the University of Maryland School of Social Work. Dr. Cardenas is an assistant professor at the University of Maryland School of Social Work. Her research focuses on intimate partner violence, particularly in the Latinx community. She is interested in help-seeking behaviors in the provision of culturally responsive and trauma-informed services. Her work aims to prevent and address the consequences of partner violence and ameliorate the existing social and health disparities in the Latinx community. Dr. Cardenas focuses on person-centered approaches to build safety and trusting environments in the healthcare and criminal justice system for those who experience IPV. She was part of the research assistantship program at the National Institute of Justice, where she worked in the Violence Against Women portfolio. Dr. Cardenas is a licensed social worker and completed her doctoral training at the School of Social Work at Rutgers University, where she also obtained a Master of Social Work. And with that, your panelists.
Hello, everyone. Good afternoon. It is such an honor to be here with you all today, and I hope no one is too tired from our delicious lunch and ready to go. So thank you for having me. My name's Linda Jean Mack. Many people call me LJ, so you're all welcome to do that as well. I'm going to start a little bit by telling you about my own career trajectory, because it really influences who I am today and also influences how I understand my own family and relationships to this work. So I came to social work after college. A friend of mine was running a substance abuse shelter for mothers who were reunifying with their children who'd been removed by the Department of Children and Families, where I lived in Massachusetts at the time. And so she asked me if I wanted to run a play group there with the kids that were in the shelter. I did that for 2 years. I loved it. It was so fun. And I realized, wow, I really like this. I don't want to be a teacher, but I like working with kids, and I really enjoy this. So I decided to go back and get my master's in social work. And I did that part-time while I was working as a case manager in a therapeutic foster care program. And we also had a 24/7 crisis line, which I worked sometimes. I really enjoyed that work. Again, I really liked working with kids, but I also didn't yet have all the skills to understand the policies and structural issues that were happening for families involved with our program. So after I finished my master's, I became the director of one of the foster care programs at our agency, and it happened to be an adoption program. I did that work for 6 years, and I joke that it was the world's worst adoption program because as I started to understand more about systemic oppression and the ways that children and families came to the attention of child welfare services, I really found myself just working to reunify children with their parents as much as possible, even though that was not even remotely the job of our program that we were contracted to do, which we talked about earlier, this idea of like what's contracted is what we do. And so I realized that this wasn't the work for me anymore. So I started doing some community mental health, and I worked as a therapist for 6 years. I only saw people who had been through foster care, who had been adopted, or were separated from their family in some sort of way. I did a lot of clinical trainings in this area. I'm an LICSW. I did a 2-year-long training with working with people in this population. And I also felt sort of obliged from all the work I had done sort of separating families to go back and work on this tail end piece that seemed really important to me. And so during that time, I learned about, people were talking earlier about pathologizing, right? So like depression, mental health, anxiety, all these diagnoses we give people. But I came to learn that the majority of the kids and adults that I had seen were also dealing with something different. They were dealing with ambiguous loss. Who here has heard of the ambiguous loss as a framework or way of thinking? All right, I see a few people raising their hands. It's often applied to people with dementia or people who someone in the family has been deported or is at war. So this idea that the person is psychologically present even though they are physically not present. So for kids who are in foster care, who are separated from their families, their mothers, their fathers, their siblings are psychologically present for them, but they might not physically be. And so a lot of these behaviors that I was told that kids were exhibiting that I worked with felt better described by the incredible grief and loss that I imagined that they probably experienced. I also come to my work with the framework of the 7 core issues of adoption, foster care, and permanence, which is Silverstein and Kaplan's work from 1982. It's been modified several times, but the 7 core issues are loss, rejection, guilt and shame, grief, identity, intimacy, and mastery and control. I think we've talked about a lot of marginalized populations today, people who are separated from their loved ones in some capacity, and I think this could apply in many of the situations we look at. Learning about this framework and working with families who have had this experience, I became so much more aware of my own family and our experiences. I grew up in multi-generational housing until I was 8 with my grandmother and my great-grandmother. My grandmother had adopted my 2 cousins who were my uncle's kids. And then when my mom and I moved out of that house, we often cared for my cousins. And then when I became an adult, they often lived with me again, and their children lived with me. So I had this long history of kinship care and many family members who had placed children for adoption or had been adopted, and I didn't even realize it until I was like 10 years into the field. So it's so funny how you start to reflect on what you're doing. And so I decided, as I became more and more aware and I became more involved in my work, I started to think more critically about the role that I played in systems of oppression, systems of family separation and removal, sometimes where it felt very, very unnecessary to me. So thus began my journey to consider getting a PhD in social work and think about these things more critically on a broader level. So right now, there's about 391,000 children who are living in foster care. That's according to the most recent Adoption and Foster Care Analysis Reporting System report. It's about a year old. But that doesn't account for, I think it's like 600,000 children who have been touched by the foster care system over that course of the year. And it also doesn't account for families like mine, where we had informal kinship care for several members of the family, and they were placed and separated from their parents. And so circumstances associated with child removal vary, but there's three that are the highest, and those are neglect, which is 63%, parental drug use, or drug abuse rather, is 36%, and a caregiver's ability to cope is 14%. So those are the current percentages of children who have been removed for those reasons. So these are not there's no explicit category for mental health, right, that says we're separating families for this reason. But I think mental health of parent and child falls under these categories, just kind of they're broadly used, and this is how they're used often. And so I wanted to talk a little bit about how mental health plays a role in family separation, and I wanted to use a case example of a case that I had worked on prior to leaving my position and starting the PhD program. I also want to say that according to recent reports from the Child Welfare Information Gateway, mental health and behavioral health are the biggest unmet need for kids who experience out-of-home placement. And many of those kids are heavily diagnosed and heavily over-medicated with psychotropic medications. I think there's been a lot of news in Maryland where that's been a really big issue lately. So I want to frame that in the lens of the 7 core issues of adoption, foster care, and permanence that I talked about, and also this lens of ambiguous loss, because I think it's really important to think about that when we're thinking about how we're diagnosing and over-medicating children. I also want to think about that in the context of their parents, because often we talk about the experiences of kids who are separated, but we forget how their parents feel. Imagine being a mother separated from your child, and you have to do this mandated service plan, right, where you get it together, talking about those contracted services, those parenting classes that you don't really need because you might need housing, you might need childcare, you might need support. This might be the worst day of your life that we've written this assessment because your kids aren't with you anymore. So thinking about all of that and how this mental health lens plays a role in whether parents are able to parent their children and whether children are able to be parented by their parents. I want to share this case with you. This case was one of many, many cases that I worked on that really informed my decision to move into more of an academic role, a teaching role in the work. But this one really reflects this idea of mental health dictating whether the parent can parent or the child can be parented. I've changed a lot of information just to be, to keep confidentiality and all that, that we really value for the people we work with. All right, so my program, one of our main responsibilities is we wrote assessments for the court and for the state, talking about that idea of assessment. Again, could be the worst day of your life. How do you make those decisions? So I wrote personally an assessment about 3 sisters who were in foster care. They had been in foster care for 5 years. They had goals of adoption, and they were removed from their parents because, and this is really interesting, right? So their mother and father were in a shelter placement at a hotel, which was common, scattered shelter sites in Massachusetts. And they went outside after the kids went to sleep and smoked a joint, which I'm sure there are probably even people in this room who have gone outside after the kids have gone to sleep and smoked a joint or had a drink and tried to relax a little bit. And mind you, marijuana is very legal in Massachusetts. I lived next to 4 dispensaries at the time this case happened. So pretty interesting that would lead to a child removal. I would also get all the records that came from the Department of Children and Families. And one of the other reasons cited in the record was that the hotel room was messy and there was a banana peel on the floor. All right, so that, definitely seems like reason to remove 3 children from their mother and father. So in this process, I interview everyone. I ask what the perspective are, what's happening, how are they moving forward with this case, reunifying the kids, working towards this adoption goal. So I had asked a social worker why all 3 siblings were in pre-adoptive placements. So when kids come into foster care, for those of you who don't know, after 15 of 22 months, if you were not able to reunify with your children, the goal changes to adoption. It's federal guidelines. It could be less than that in some states. I'm not here to talk about that today, but don't get me started if you want to have a conversation. So they do something called concurrent planning, where they find an adoptive match for this child, and then the parent works to reunify. They have a mandated service plan that says, you're going to do X, Y, Z things that we've decided are what the rules are for you to get your child back, right? It can be very punitive. It can be very difficult. It's a lot of hoops to jump through. And it almost always, I would say, in 10 plus years of working in the child welfare system, I never not saw therapy on there. Like, I don't think I've ever not seen it on there. It's been on there every time, regardless of if the person really needs therapy or not. It's always there. So I asked a social worker what the deal was, what was happening, and I learned that the children's father had completed consecutively for the past 5 years every single item on the service plan, except he would not go to therapy. Why didn't he want to go to therapy? Because he went to church and he went to church counseling and he didn't believe in therapy. He thought he was getting his services there and he just refused to go. You weren't going to tell him he was going to do this, but he was going to do all the other things. He also visited with his daughters every single week, spoke to them on the phone 3 or 4 times a day. But here they remained in foster care because he would not complete this one thing that they told him to do. So I asked a social worker, what the plan was, and she says, well, until he makes some other mistake, we don't have evidence for a termination of parental rights, so we're just gonna sit here with the kids in foster care until that happens, and then we can go through with the adoption. And then I asked more about the kids, who I would be writing the assessment on, the 3 girls. And I was told that the youngest daughter had something called reactive attachment disorder. Who is familiar with reactive attachment disorder? All right, I see a lot of hands. So reactive attachment disorder, sometimes called RAD, is a very common diagnosis for kids who experience foster care. It is used way too often. It's not a good diagnosis. It follows you for the rest of your life. I even personally knew a young woman that I worked with who couldn't join the military because she had a RAD diagnosis on her file from when she was 5 years old. So there are consequences, right? When we give diagnoses to kids, they follow them forever. So then I was told that the other daughter was just so bad. She was acting out all the time. And so if this father cannot get his mental health treatment needs in order and he won't go to therapy himself, then how am I supposed to send home these severely mentally ill children to go live with him? And 3 of them at the most. When I met the kids and met their foster parents, I did not see 3 mentally ill children. I didn't see 2 mentally ill children. I didn't see 1 mentally ill child. I saw a sweet little girl who the foster parent told me her RAD symptoms were being quiet and shy around new people at 8 years old. And the other child, was seeing had 5 therapy appointments at home a week, and they were in the home, and they were, again, this contracted service idea. And her foster mother spoke Spanish, and the young woman spoke English and Spanish, but the therapist who was supposed to provide in-home services only spoke English. So they weren't actually doing any of the things that they were supposed to be doing for the past 2 years because they didn't speak the same language with each other. All right, sorry, I just lost my train of thought here. And then so I finally, made some recommendations. And like I said, just to close this, I think I could go on about this case all day. I could probably go on about foster care all day and how mental health mandates prevent families from being together unnecessarily. But I don't ever know. I wish I could tell you that I knew what happened to this family. I made my recommendations. I got an email back saying that people were surprised by what I said, which I thought was funny. I recommended that they reunify with each other. I will never know if that happened. I think until we address many of the issues we talked about today, there will be so many more families who have these experiences who will end up having to live with the consequences of the mental health challenges that come from being separated from their families. Kids who age out of foster care are more likely to be incarcerated. We've talked about the damages that happen to people's mental health when they're incarcerated, what that's like. So I hope that coming to this event today, talking about it, at least will make some sort of shift at some point for some of us. And I try to be optimistic, as we all said. So thank you so much. I'm going to wrap up, and I look forward to your questions after.
So in late March of 2020, the Massachusetts Supreme Court weighed in on what it was witnessing across the state with juvenile detention centers. Public defenders had organized and rallied and made arguments to courts across the state that children should be released at the beginning of this historic pandemic, arguing that they were particularly vulnerable in those detention centers that were acting as locales for dangerously rapid transmission and spread. Now, one of the things that the state prosecutors did at those hearings where the lawyers were asking for kids to be released, they argued that if the minors would be released, they should be subjected to digital surveillance in the form of electronic ankle monitors. And this is what the Massachusetts Supreme Court was wading into. The Supreme Court stepped in and it issued an order halting the use of those electronic ankle monitors. The court noted in its order, quote, "In light of the public health concerns regarding COVID-19 pandemic and the actions ordered by the governor in connection therewith, the Supreme Court, pursuant to its superintendent's authority, issues the following order to protect public health by reducing the risk of exposure. Whereas, when a court orders GPS monitoring as a condition of release or probation, whereas a GPS bracelet cannot be affixed without probation service personnel coming in close proximity with a juvenile, whereas the act of affixing a GPS bracelet cannot be accomplished while simultaneously engaging in social distancing, whereas the act of affixing a GPS bracelet therefore inherently poses a degree of risk of exposure for both probation service personnel and juvenile. Now, therefore, the Supreme Judicial Court, having balanced the public safety needs for GPS monitoring with the potential risks to the public health from the act of affixing a GPS bracelet, hereby orders on March 24th, 2020, 1, no court shall order GPS monitoring as a condition of release or of probation unless a judge finds that there is a compelling public safety need. At the time I came across and read this order, I was admittedly struck by the absurdity of it. Not absurd in the sense that correctional officers could not contract COVID, but rather that this practice of digitally shackling children, which I had fought years against tirelessly as a public defender and then argued against its harms and theorized about it as a legal scholar, would temporarily be realized as necessary and justified by the fact that juvenile justice officers could catch COVID, or that it may deepen a public health crisis. I could not help but think about the 16-year-old that I had represented just a few years prior, who was a star football player, while managing being a part-time fast food worker and beloved big brother, who found himself in juvenile court for participating in a cafeteria fight that turned into a brawl. He had been assigned to electronic monitoring, and not long after I watched them connect that device, I watched him disconnect from some of the most important aspects of his young world. He was no longer able to play football because of the supposed danger of having that unit on his leg. He was fired from his job because his manager said that he didn't want customers seeing it. He drifted in school. And when Thanksgiving came up shortly thereafter, and most of his family went to spend the day at his grandmother's house in Virginia, he was forced to stay home alone, unable to get a hold of the DJS personnel responsible for giving clearance. And I watched him deteriorate. I could not help but think of the young girl around the same time who I represented, who found herself in juvenile court for a similarly normal adolescent behavioral issue at school. Her mother believed that she may have been connecting online with some older guys who seemed like they were taking advantage of her. Although she was the victim, and although the court was failing stupendously to provide services to her, the judge placed her on electronic monitoring for, quote, her safety, unquote. As I reflected on that Massachusetts Supreme Court order at the height of COVID, I thought, were all these harms we were seeing before with electronic monitoring not enough of a threat? Is this form of electronic surveillance not a compelling public health crisis in itself? I want to spend my time talking about the rise of e-carceration in the juvenile legal system as a purported progressive tool for positively regulating the behavior of minors, supposedly without connecting the dangers and harms of being in prison. I want to talk about it and situate it within the larger critical discussions at the intersection of race and technology. And if there is time, maybe briefly flag a few areas for further advocacy, research, and thought. So when I speak of e-carceration, I refer to the digital outsourcing of aspects of prison into communities under the guise of carceral humanism, the repackaging or rebranding of corrections and correctional programming as caring and supportive, while they still cling to punitive culture. Electronic ankle monitors are a prime example of e-carceral tools and logics. Electronic monitors are obviously high use now. They typically operate through ankle units that strap around the leg for that person to be monitored digitally. Like cell phones, these devices have batteries that need to be charged through bases that connect through electric outlets. When in operation, these devices collect and share information with a central computer and data system usually maintained by corrections departments, but more increasingly today, private corrections affiliates and companies. The most recent development in electronic ankle monitoring technology is the leveraging of smartphone capabilities to allow online apps to pair with these digital devices. Those placed under surveillance with these upgraded capabilities will now have alerts coming to their phone, indicating when they need to be in the house, indicating when they are going to a location where they are not allowed to be. Even more, there is the prospects of adding additional verification measures along the lines of biometric information, using fingerprints, using facial and voice recognition as well to verify those who are monitored. So I think it's important here to stress a few things about electronic monitoring of juveniles. First, electronic monitoring emerges out of this movement toward community corrections. This euphemism is quite simply based on the idea of we bring the prison to you. However, the state would characterize it as an intermediate sanction, so perhaps you can refer to it as that. The earliest forms of community corrections were house arrests, community service, day reporting centers, intensive supervision and probation programs, drug courts, and boot camps. These programs gained popularity in the 90s as the heavily punitive criminal sentencing began to receive a healthy level of rebuke and critique. Their purported appeal is in their seemingly more humane treatment of offenders versus detention and their potential to provide services that can lead to change within offenders, right? Keep that in mind. The benefit of these early intermediate sanctions, as the state would call, however, have been questioned. There are three important aspects of the program that have been identified as exacerbating the problem of race and class bias within the criminal justice system. Who we see as the typical target population for these intermediate sanctions. B, the control orientation of the specific sanctions geared towards social control. And C, the failure to integrate appropriate treatment strategies into correctional programming. The programs have been criticized for contributing to net widening of the criminal legal system and extending social control for racial minorities, as they tend to target African American and Latino offenders who are most likely to be released without the need for such programming. The tendency has been to target probation-bound versus prison-bound offenders. Even more, these community correction programs have been scrutinized for their prioritization of controlling offenders by piling on multiple special conditions, which also can happen to contribute to frequent violations. And what happens is when you have frequent violations and people are brought back into court, additional restrictions are placed, which keep ratcheting up until the person ultimately ends up back incarcerated. The focus on controlling offenders has come at the expense of attempts to integrate treatment and implementation of community correction programming and has received wide criticism. The biggest failure here is that most of the programs have stated goals for fostering rehabilitation, specifically in the juvenile context. They say these things will contribute to rehabilitation, trust us. Yet the programs themselves do not involve treatment or therapeutic types of services at all. They don't even attempt. Most recently, the community corrections model has been propelled by a second wave of programming reliant upon technology-driven surveillance. These programs vary and are constantly evolving as the technology advances. This new wave of community corrections is touted as maximizing effectiveness in determining the best supervision and treatment strategies for offenders. I'm taking this right out the brochure. Minimizing racial biases and reducing overall recidivism. This new wave of datafied community corrections programming has been criticized for presenting the same problems associated with the first wave: racial discrimination, overemphasis on control versus rehabilitation, and the failure to provide treatment services. Yet you find organizations like the Annie E. Casey Foundation that promote the practices of viable, progressive alternative to detention. I have a beef with Annie E. Casey Foundation. I hope they aren't providing funding in any sort of way here. Second thing to note about electronic monitoring is that it is extremely invasive and restrictive. People on monitors are subject to anywhere from 6 to 58 separate rules. These rules are usually contained in a short user agreement or contract that parents and children sign as a part of being placed on the monitor. The agreement generally contains the terms and conditions and often stipulates that any violation of the contract may result in revocation, i.e. that child, you're going back to a cage. As my colleague Kate Weisberg notes in a recent article called Punitive Surveillance, quote, electronic monitoring conditions often impose significant burdens on friends and family, unquote. So on this panel, we're sort of thinking about in the home. Some agencies forbid people on monitors from having house guests, gatherings, or allowing anyone to move into the house without permission. Search conditions also impact everyone in the home, as agents are permitted to search the entire home of the person on monitoring. In Virginia, people who live with someone on the monitor must provide basic contact information as well as their criminal history, their highest education level, their substance abuse history. In Alaska, people on electronic monitors are prohibited from, quote, babysitting or being a primary caregiver for any person, children, or pets without approval, unquote. In San Diego, everyone who lives with a person on the monitor must sign a cohabitation acknowledgement form that contains additional rules. In places like Oakland County, Michigan, the rules require a responsible party of the community to take on the role of police by taking custody of the person and agreeing to monitor the defendant and report any violation or release conditions to the court. Deputizing your siblings, your parents, your grandparents, your uncles, and turning family members against one another. People on monitors are also restricted with respect to social and familial relationships. Rules in Dane County, Wisconsin expressly prohibit leaving the home for any social, religious, or family function, like my client. There are also restrictions on who people on monitors may interact with. In Mississippi, people are prohibited from associating with anyone that has a bad reputation. In Kanawha County, West Virginia, people on monitors must not allow people of disreputable character to visit their home. And in New Mexico, rules forbid people on monitors from interacting with people on parole or probation, right? Or anyone that parole or probation officer deem detrimental to their probation supervision. A lot of discretion there. Lastly, there are also restrictions on housing and where people may live. Several agencies require that people on court supervision, including people on monitors, only live in approved housing, and in a few places, people on monitors face additional restrictions related to temporary housing, subsidized governmental housing, or hotels. So to sum it up nicely, I tell you it like the Department of Corrections tells people who are placed on monitors in York, Pennsylvania. Quote, when you are wondering whether or not you will be permitted to go somewhere, ask yourself the following question. If I were in jail, would I be able to do this? If the answer is no, then chances are that you will not be able to do it while on electronic monitoring. Unquote. And this does not even begin to broach the question of costs and finances, levying additional burdens on families. Lastly, these associated harms and collateral consequences strain a child's connection to their community and family through isolation and marginalization at a time when it is critical for a child to gain greater connection and investment in their own communities. Social marginalization in this correctional context is defined by what I call its sever and tether effects, where electronic ankle monitoring programs act to sever young folks from their community and families through the erection of significant barriers to reentry, while simultaneously tethering them to a surveillance regime wholly unconcerned with rehabilitation and reintegration. Electronic monitor programs act to push those under surveillance further on the margins of society, divorcing them from the very things that are necessary for reentry, while at the same time failing to make us any safer, nor significantly reducing prison populations. In fact, the aim of rehabilitation envisions supposedly putting youth on the track to being healthy, contributing members of their communities and society. Yet such marginalization that comes along with electronic monitoring could lead to even greater antisocial conduct and misbehavior that juvenile courts attempt to steer kids away from in the first place. This becomes even more vital when considering that life paths set in adolescence can have a major impact later in life. And there are reasons to believe that early altering of these trajectories in positive ways can have a larger effect than the same intervention applied later in adulthood. Thus, electronic monitoring may actually be a counterproductive measure that jeopardizes a child's chances at successful life outcomes. Adolescence is an important time for developing a new sense of self and identity, along with the cognitive ability to imagine oneself in the future in ways that create positive emotions. It is also a time in which, unfortunately, negative affective appraisals, can have great impact. This complex processing of thoughts and images can create strong feelings in adolescents that are capable of altering motivation. So when faced with trauma, when faced with stress, when faced with lower self-esteem, adolescents experience deep emotions that they are seldom equipped to deal with in positive ways. Thus, in considering the potential harms of electronic monitoring, effects such as stigma, effects such as shame can have potentially crippling impacts on healthy youth development. I've seen it. By understanding that adolescence proves to be one of the most difficult periods for youth to develop positive abilities to think strategically, to make long-term plans, to set life goals, to learn social rules and navigate complex situations as cognitive and emotional systems are integrated, the punitiveness of electronic surveillance of youth is better understood. It is better assessed. It is better seen. I don't want to take too much more time here, but I will say a few more things. How do we respond to or think about or navigate this reality, this problem, this harm? I could talk for some time about litigation that has taken place against private correctional companies for extorting families in this context, with the expenses charged and sort of using court as a financial whip on families. I could talk about sort of working towards efforts to undo the years of politicization of juvenile offenses. I could talk about communication strategies that challenge this narrative that says being out on an electronic monitor is better than being in jail. But I'll talk to you very briefly about an area that has sort of captured my mind and where most of my efforts these days lies, and that is in the area of race and tech informed policymaking in legal jurisprudence. Most of my research, as Professor Johnson noted, is in the area of race tech law surveillance. There has been a ton of work happening in the space, which is being referred to as critical race and digital studies, right? This intersection of critical race theorizing and critical tech studies and theorizing as well. And there are a couple of things that comes out of that body of work and theorizing, of which I'm a part of, that I think is relevant for informing policymaking, decision, and legislating and advocacy in this space. And first is sort of the promotion of the idea that technology is socio-cultural, right? The notion that technology does not develop separate and apart from society. There's a tendency in the area people refer to as techno-determinism, right? To think of technology in these utopic ways, right? That technology progresses on this upward arc. I think about, I'm not sure if any of my students are here, but just the other day I teach a class on race, tech, and the law, and we watched a Microsoft commercial in which the rapper Common talks about artificial intelligence. And he talks about it as this beautiful tool. He says, artificial intelligence is a tool. It's like for the rapper or the musician, it's the microphone. Using these very images and language of trust, like we should trust these technologies. We push back on that and sort of expose the inability of technology to respond to large social problems like mass incarceration. Electronic monitoring is presented as a solution to mass incarceration, and it is not. It is techno-solutionism. Second, I want to raise in this area is sort of elevating being able to historically contextualize what's taking place here. Sort of monitoring and the promotion and emphasis on surveillance of Black and brown people in this country is connected to a long historical arc of surveilling those communities, surveilling those persons, surveilling those bodies. And then lastly, sort of being able to dig into and investigate profit motive in this space. One of the things that is transpiring in this realm is that private correctional corporations are seeing an opportunity to take a hold of and latch on to this idea of community corrections, to hop on some of the pushback and critique of getting people out of prisons. And they come to jurisdictions and they say, hey, we hear you're releasing or considering, reducing your prison populations. How about we monitor them for free and help you with this notion of public safety for profit? So there is an intersection of what we're seeing as surveillance capitalism and racial capitalism. I have an article, if anyone has a chance, a very short article called Data as the New Cotton, right? Which sort of intervenes in a space where there is dialogue about data being a gold or the new oil. And I sort of attempt to put a racial lens there to have a better understanding of the history of capitalism, specifically in America, by invoking the image of cotton. And I think sort of allowing this critical scholarship to guide us in policymaking will lead us to better outcomes, and I'm thankful to be on the forefront of that. So looking forward to your questions. Thank you all.
Hello. If anyone needs a wiggle break, please feel free to take one. And we may have tricked you. In true social work fashion, Dr. Cardenas and I are actually going to co-present this last piece, so there aren't two additional presentations. We're going to take the conversation about being sort of this intersection of mental health and legal systems response in the context specifically of intimate partner violence. And so you'll hear us say IPV in short, but we mean intimate partner violence. The Centers for Disease Control and Prevention define intimate partner violence as physical, sexual, psychological abuse, threats of those kinds of abuse, or stalking committed by a current or former intimate partner. And so when the image of physical violence pops up, that's not the entirety by a long shot of what constitutes intimate partner violence. You'll hear us commonly, Dr. Cardenas and I, say the term survivor. I tend to use the term person who has experienced intimate partner violence, but that's quite a mouthful for speaking about it. So we opt for the term survivor, knowing that some folks prefer the term survivor, some folks prefer the term victim, and some don't like either term for many different personal reasons. According to our most recent national data, approximately 1 in 2 women and 2 in 5 men will experience what's called contact, physical, sexual, or sexual violence or stalking committed by a current or former intimate partner in their lifetime. The prevalence is huge. When we consider psychological and emotional or mental abuse as part of the picture of intimate partner violence, the numbers rise even higher. And although much less research has been conducted to investigate different relationship configurations and the diversity of families and communities that exist, we know that the IPV experiences of folks who identify as lesbian, gay, or trans or non-binary gender identity, for those communities, especially for folks who identify as bisexual, the prevalence of IPV is even higher than their heterosexual counterparts. And the prevalence clearly, just based on those statistics, varies by gender and sexual orientation, by gender expression. It also varies by race and ethnicity. And with not, just for example, from the most recent available data we have on this at the national US level, with non-Latinx multiracial women experiencing the highest rates of IPV, followed by non-Latinx American Indian and Alaskan Native women, non-Latinx Black men, and non-Latinx Black women. But what does IPV actually look like? It's so complicated. Every survivor's story and experience is unique and is at least somewhat dependent on the multiple identities that they hold, such as race, ethnicity, gender, class, ability, documentation status, sexual orientation, and many more diverse identities, and their intersections. And importantly, all of these identities are tied to systems of privilege, power, and oppression that shape everyday experiences of the world, as well as everyday experiences with the legal system that they may or may not encounter. And although IPV is commonly thought to manifest as a cycle of violence, folks in the audience might have even been trained on the cycle of violence, where IPV has an escalation phase. That escalation phase leads to a violent outburst, and it's followed by a calm or honeymoon phase, where forgiveness might be given or sought by someone. That's not the reality for many or most survivors. And survivors have many very good reasons for staying in violent, intimate relationships, including that leaving a violent relationship is the act that puts folks at the highest risk for being killed by their current or former partner. And the detrimental consequences of experiencing IPV are wide-ranging and can affect survivors, their families, and their communities in both the short and long term. And consequences might include physical injury, and for many survivors, that is a piece of their story. And that's commonly what folks might first think of when they think of intimate partner violence, but the consequences are so much more than physical. They can be financial, they can be reproductive, they can be social, and very, very commonly are emotional or psychological or have mental health implications for folks. And survivors are at heightened risk of experiencing many mental health concerns, including depression, anxiety, post-traumatic traumatic stress disorder or PTSD, as well as suicidal ideation, suicide attempts, and dying by suicide. And the possible legal responses that folks might or might not take or interact with vary. Largely as a result of the anti-rape and anti-domestic violence women's movements and the passage of VAWA, or the Violence Against Women's Act, which first passed in 1994, legal remedies or responses for survivors of IPV legal remedies are really the best or sort of the best funded and very often go-to remedies or recommended responses for aiding survivors. And there are many possible ways that someone might interact with the legal system, whether it's the criminal or civil response sides. Most commonly, and something that I was involved with quite a bit as a social worker, was survivors might access domestic violence protective orders, which are also sometimes called restraining orders or no contact orders. They might seek arrest, prosecution might happen, civil claims might be part of the story, custody proceedings, and even visas. So today, Dr. Cardenas and I hope to open up dialogue about why accessing legal remedies often is complicated, problematic, and has a range of serious mental health-related implications for survivors. And those implications and those systems are experienced differently based on folks' different identities that they hold. IPV also typically results in trauma. A lot of the themes that you'll hear us talk about have crossed the other panelists' conversations today. On the federal level, there is a push for trauma-informed care and responses for survivors of IPV and for folks who use violence within intimate relationships. And when someone has had their power and control and autonomy taken away in the context of IPV, a key part of trauma-informed care or trauma-informed services has to be honoring and giving power back, giving space for self-determination. In our collective experience as social workers working in this space in particular, serving survivors as well as researchers addressing IPV, we have seen time and time again how legal processes addressing IPV are not set up in any way to give back or to honor folks' power and control. And in fact, instead contribute both to re-traumatizing people who have experienced IPV and causing additional traumatic experiences, which then goes on to exacerbate mental health and other consequences that survivors might have.
Okay, so, can you hear me okay? I think I'm too short. Okay. All right, so survivors have different experiences because what we heard from Dr. Graham before, they have different identities, right? So I do want to emphasize that not everyone who experiences intimate partner violence seeks assistance from the legal system. And some of the reasons may be because they fear retaliation from the abuser. There may be a lack of knowledge that the legal system may provide some assistance. There may be also some cultural beliefs that may deter some help-seeking behaviors. But for the survivors who do choose to seek assistance or engage in the legal system, some of those reasons may be because they're looking for protection, right? So we already heard that the legal system can provide immediate protection to survivors of intimate partner violence or IPV by issuing restraining orders, removing the abuser from the home, or even arresting the abuser or the person who perpetrates the abuse. There is also legal recourse, so the legal system can be seen as holding the abuser accountable for their actions through criminal charges and convictions, and that could provide to some individuals who experience IPV some sense of closure and justice. There's also the access to resources. So some individuals may choose to engage in the legal system because then they will be connected to, although limited, to counseling services, financial assistance, housing assistance. While we consider those potential positive outcomes, we should also consider that there are a lot of several negative implications for those individuals who decide to engage in the legal system. Let's consider the mandatory arrest laws and no job prosecutions. So the mandatory arrest laws for intimate partner violence requires that police arrest or make an arrest whenever there is a probable cause to believe that there was an instance of intimate partner violence, even if the survivor of that violence opposes the arrest. For no-job prosecution, policies generally require that prosecutors proceed with an IPV case regardless of the desire of the survivor of that violence. So while these laws and policies can be life-saving for some, it is also creating impediments to survivors' agency and autonomy. So these responses are problematic. Some consequences of these problematic responses include survivors' arrest for intimate partner violence, the failure to arrest the person who's perpetrating the abuse. For survivors who have a documentation status that is precarious, it results on their own deportation or can result on that, and it has happened. And then there is dual arrest. And in fact, there is data that indicates that arrests of women, in the cases where women was the survivor of intimate partner violence, so in those cases, their arrest went up when mandatory arrest laws started. And this dual arrest has happened when both parties were injured, so the police weren't able to determine who was the primary aggressor. So having these mandatory policies, right, has offered mostly the women's movement some control over the state response by increasing the likelihood that police and prosecutors will not dismiss and reject IPV cases. While that might be important, we need to be critical of the impact of those policies on individuals who are the survivors of intimate partner violence, the families, and the communities, particularly when we're talking about individuals who are holding minoritized and marginalized identities. So in essence, these policies make irrelevant survivors' preferences as to how to proceed with their cases, the arrests, and therefore, the implementation of such policies can and do continue to perpetuate the power imbalance and control that we see in intimate partner violence dynamics. Some individuals experiencing intimate partner violence, like I mentioned, may choose to engage in the legal system because either they lack knowledge of other systems that may be able to assist them, or they may feel that they're in danger and at that moment, and they decided to seek an immediate solution, right? But for a lot of those individuals who made the first decision to engage with the legal system, a lot of times that's the last decision they're able to make within that system. So for example, in the immigrant community, so survivors who engaged in the legal system and then realized that their partner who, let's say, has a documentation status that is precarious, will be deported. They cannot stop the process, right? If that's not what they want and wish. For individuals who live in poverty, who engage in the legal system and then realize that the arrest of their partner, their abusive partner, will then result in maybe stopping child support or the financial support that they need to leave, they cannot stop the process. For communities of color, when IPV survivors engage in that system and then realize that the interactions are based on racist ideologies and they don't want to be part of that system and they don't want their abusive partner to be part of that system, again, they don't have the authority, right, to stop that. Similarly with survivors who are part of the LGBTQ plus community, and then they realize that interaction are rooted in sexist ideologies and are heteronormative. There is no autonomy and agency. So we can say that the legal system response exercises power in ways that reinforces the disadvantages experienced by survivors, and in ways that reinforces the disadvantages experienced by members of minoritized communities. And it does this by diminishing survivors' decision-making power and autonomy. So then we can also say that while the legal system response can empower some survivors of intimate partner violence, it also simultaneously disempower others. Now, given what I just mentioned, we need to also recognize the potential impact that engaging in the legal system can have on survivors' mental health. So because the legal system does not always support survivors' control over their case, right, diminishing their decision making process, their choice and autonomy, and actually replicating some of those IPV trauma-related dynamics. We can say then that the legal system does not provide or always provide, there's a dilemma there, or a debate, trauma-informed care, right? And we already heard very briefly, trauma-informed care centralizes the understanding of the effects of trauma in all human services delivery systems. And specifically in that context of intimate partner violence, key elements at the organizational level for a trauma-informed practice include restoring choice and control and promoting emotional safety. Therefore, the legal system can inadvertently increase survivors' sense of vulnerability and disempowerment. It re-traumatizes survivors, which then contributes to exacerbating the mental health needs. In all of this, we should also consider that how these mental health implications, both from the partner violence experiences, but also potentially from the engagement in the legal system, impact minoritized populations who we already know experience a great mental health disparity. So for example, one study found that among Latinx, lesbian, gay, and bisexual youth, those with experiences of intimate partner violence were 5 times more likely to report suicide planning and 9 times more likely to report suicide attempt. Now, this impact on survivors' mental health may become even more harmful when compounded with the effects of discrimination survivors of color face. So some studies have indicated that having experienced both IPV and racial discrimination increases the prevalence, there is a higher prevalence of anxiety than either experiencing intimate partner violence or racial discrimination alone. We also need to consider poverty, right? And I already mentioned that some survivors may be financially dependent on their abuser. So when they are engaging the legal system and they want to stop the process, disengage from the process because of the financial dependency, right? The financial strain, that creates a stress that then affects the mental health well-being. Overall, interacting with the legal system can create additional layers of trauma on top of the trauma that already resulted from the IPV experiences. And for some others, the trauma that resulted from the interactions with structural conditions that they face because of their diverse identities. And I'm talking about racism, sexism, xenophobia, colorism, right? So to start wrapping up here, these practices are now survivor-centered. And so to move towards a survivor-centered approach, we need to acknowledge that survivors may define justice in different ways, right? So some may define it as prioritizing accountability, safety, rehabilitation, and we need to start there. We need to acknowledge that. And then move forward on how we are approaching the needs of survivors for them. And I'm going to pass it on to Dr. Gant.
So just to wrap up, I want to share a few additional thoughts, ideas for pathways forward, and raise some questions. I appreciate this opportunity for all of us to have dialogue around some of these issues. So arguably, although legal responses to IPV are really the best funded go-to response in a lot of cases for folks to seek some type of remedy or support for the violent experiences that they're having, legal responses to IPV arguably are not effectively serving those who are meant to be served. If the legal system is in fact meant to help survivors, and help can be defined in lots of different ways, we also need to consider the harms that it's causing. And we've only scratched the surface, so to speak. We haven't even talked about folks who use violence within intimate partnerships, which is an entire other conversation about how incarceration also causes many different harms for survivors as well as those who use violence in relationships. So as we end, I want to ask us all the questions: what are our alternatives? How might resources be put towards other responses? How do we make that move from spending millions of dollars annually at the federal level to carceral responses to IPV, to putting that elsewhere? And some service providers and scholars, both in the United States and even more so internationally, are exploring alternative responses, some that are more or less connected to legal or carceral responses to IPV. And for example, although controversial in at least some circles, there's work to try and understand if and when applying restorative and transformative justice models or methods or practices might have potential here. And there might be some option for addressing IPV, at least among some subset of folks who experience IPV with restorative justice. Although we also want to acknowledge that that type of response, there might be a population that really benefits from that in many different ways. And it also is a process that needs to be developed with intention, with caution, and with survivor input. We also could put forward more funding into prevention. That's the space that I work in now. Now that I'm more in the education and research space, we could be putting lots of that funding towards primary prevention efforts or stopping violence before it starts. That could look like financial empowerment programs. That could look like poverty reduction programs. It could look like sustainable housing programs, safe housing, healthy relationships programs for young people, and more. And those are areas that receive much less attention and much less funding at both the federal and local levels. And with advocacy and perseverance, I hope we can change that. And so we invite your responses and feedback. Thank you.
Can we give another hand to our panelists? So I guess we reached the point where we should ask our panelists some questions. So let's first start with the audience. Are there any questions for our panelists?
This question is for Mr. Arnett. So with all that you said about the glaring issues with the digital monitoring system, how do you think at some point this system got represented as to be a better option? Because so many people think in the community, I work with women who are coming out of incarceration or they're on the box, as they call the ankle monitor. And all I really hear is about the barriers. They're like, I had to stay at work 1 minute late. And they started calling my job. They started doing all these things. Of course, that alarms the even well-meaning supervisors may not want to have to deal with that type of thing. Or, I just stepped 1 foot off the property to get my Uber Eats order or something like that. And it's that sensitive that they got flagged, doing something very normal, not criminal. But anyway, somehow it's like better to be on digital monitoring, but clearly there's way more, there's a bunch of issues with it. How do you think it got represented to be better than being incarcerated?
Thank you. Is this on? People who can hear me? Okay. Yeah, really, really good question. I think a couple of things contribute to sort of the marshaling of resources towards electronic surveillance. I think obviously there's the narrative of this is better than being in jail, right? There's also in popular culture the way that electronic monitoring is presented, outside of the people who it's typically being ushered upon. You think about Martha Stewart and Lindsay Lohan and some of the other, even in the context of Bernie Madoff, and folks, look at it as a slap on the wrist in those sorts of contexts, right? There is, I often say, I speak on this issue from great experience, right? So there's nobody in this room that argued more for people to be placed on electronic monitoring than me, right? Because I was a public defender and had to do that every single day, and it was the way that for people to get out. And it is better to be out than to be in. That's clear. I think the investigation tends to stop there, right? We don't ask the follow-up questions around, well, what is this doing, right? This is better, but is it enough? Is it what we're supposed to be doing? Is it helpful? We don't get to those questions. I think that's part of it. Also, part of it is to be quite frank, neoliberal progressives, who oftentimes don't have the experience in these settings, are on the forefront of pushing it as a positive alternative. I talk about organization. I don't want to pick on any E. Casey Foundation, but it's just because I've spent a lot of years working on their detention reduction alternative initiative, so I can have beef with them. Folks that push this without having an understanding of how surveillance has been used to sort of cripple our communities throughout history, right? So the decision makers, those at the table, are using it as a way to build reports of, to send grants, to get funding. Those sorts of things come into play. And I think undergirding all of that is we never really get at the core of what is taking place when these things are being pushed, and it is the inability to move oneself from this idea that Black people need to be monitored. Yeah. Right? You cannot, you never get at the core of what's really motivating that. And that has, and for Black people, that has been the reality from enslavement, right? That you need to be watched, that you need to be monitored. And one of the things that I often say over and over again is that Black people have always wanted to be seen, but not monitored, right? Not surveilled. So I think that plays in there. And then lastly, one of the things I was mentioning at the end is sort of finances, right? So this is big money, billions of dollars is being invested in. I'm a part of a group of advocates, lawyers, law professors, impacted folks, communities, nonprofits who are thinking about sort of carceral surveillance practices. And we have been trying everything that you can imagine to sort of be able to push back on what's happening, right? So communication strategies, sort of developing legislation. We put forth legislation in California and Illinois to sort of limit the offenses in which the court can place a juvenile on electronic monitoring. We have tried to sort of develop litigation strategies around these contracts that children have to enter into. We have sort of been theorizing it and putting out a scholarship in this space. Like we're doing so many things, but when you have so much money invested in these practices, it's hard to get away from that. And the last thing I'll say, because I've been talking a lot, one of the last ways I'll say is it's a safeguard for crucial decision makers like judges, right? Because one of the biggest challenges we have in this space is that we gain some ground, and then there's a big news story about somebody who cut off their ankle monitor and drove a car into a building or hurt someone or killed someone, right? And then everything is undone, right? When the vast majority of people do not need this sort of surveillance practices, but judges, knowing that, they use it as a safeguard, right? So if I release you and the heat comes back on me, if something happens, at least I can put you on this. So maybe there's something there where I can say, hey, I put them on this, right? So I think those who are in decision-making powers in terms of the nonprofit sector, those who are in decision-making in terms of the courts and prosecutors, et cetera, all play into this in ways that I think is disparaging. Sorry, that was long-winded.
I have a question, and I think that this was like a common theme that was in everyone's presentation. Do you all think that the legal system or the institution of the law is working in the way that it was intended to work, right? Like my dissertation chair, Jerome Shealy, says that the intersection of the law and social work demonstrates, even though it purports to help folks, that it's really just a system of management, right, for people, whether it's, survivors of, intimate partner violence, whether it's families, the separation of families and social work, or whether it's management of young people's bodies, so that they can't play sports because they're on the box. Do we think that the system is working the way that it's intended to work?
Yes, I do. I think, so I made a mention to the Adoption Safe Families Act in my talk, this notion that if a child's in foster care for 15 or out of home placement for 15 out of 22 months, we're supposed to work toward adoption. So, yes, like judges, stakeholders, attorneys, child welfare workers are actively working to uphold those laws. And I think that, the system has been working to separate families in this country since we came here, and separated Native American children, separated Black children through slavery. I mean, I think that we continue to do what we designed the system to do.
I agree. Yes, especially with intimate partner violence. How it started was the criminalization of partner violence, right? Through the Violence Against Women Act in 1994, instead of really addressing what is contributing to partner violence, right? These stressors at the structural level, the factors. So from that stance, it is intended to criminalize and to prevent intimate partner violence, which I'm not sure that has happened. No. But the criminalization of that behavior, that was the intent of it, right? So from that standpoint, that's what it is. Now, if we try to think about, did it really wanted to help individuals within an intimate partner violence dynamic to get away from the violence, but that was not the intent of it. So.
I can just add a little bit to that, just sort of broadening the lens out. I think that laws as they exist and the legal response, especially in the field that we're talking about, maintains the status quo, maintains systems of privilege and oppression that exist at a structural level, and that is intended, I think. When we're talking about IPV in particular, a lot of some of the laws that you were mentioning, sort of policies around mandatory arrest, no-drop prosecution, the way that those came about were because of class action lawsuits against prosecutors for not taking forward cases. There were class action lawsuits against police, law enforcement agencies for not arresting in certain situations where harm came to the person. And it was really, I learned a lot of this from Professor Lee Goodmark, who is faculty here, and from other similar legal scholars who have really dug into why those laws came onto the books. It was really a lot about liability and protecting people from big suits being filed against them, which I would not like that to be the intent, of the law and policies that are on the books. And as a social worker, I wish that the core and the outcomes that we were looking at were what people identify as the outcomes they want, and have to have power and control over their lives and autonomy and things like that. But I don't think that is what the intent was of the laws, and I think that the outcomes we're seeing are pretty consistent with that. That makes sense.
Oh, yeah, I can keep that. Okay. Keep that. Did you want me to respond to that too?
Yes.
So, yes, short answer. I think our to take a step back as well, I think our laws reflect those who were at the helm in developing our constitutional order, right? So from the drafting of the Constitution, but also certainly throughout the years in the development of constitutional jurisprudence, which has been for so long white men, white elite men on the forefront of shaping that, and the laws tend to reflect that limited worldview and perspective. The area of law I think about the most is Fourth Amendment. And one of the things I sort of talk about and sort of reflect on is, what would Fourth Amendment jurisprudence, right? So Fourth Amendment is about having the right against unreasonable searches and seizures without police officers having to get a warrant. Like, what would the jurisprudence with respect to Fourth Amendment look like if those who were enslaved, were involved in interpreting the Fourth Amendment from its foundation? What would that look like if indigenous folks and community were able to weigh in on what the Fourth Amendment should look like and be shaped? I think we would be in a different place. And the other thing I'll say too is, because my comments here are about minors in a juvenile court. Juvenile court started as this experiment focused on rehabilitation. Like, we're supposedly seeing these things happen to children. We're going to develop this court, and we're going to provide an opportunity not to punish kids because we are becoming enlightened. At the end of the 19th century, beginning of the 20th century, when the first juvenile courts came around in Chicago. But what we know about that history is that at the turn of the 20th century, when the juvenile court first opened and all of the other subsequent juvenile courts, Black kids were excluded. Right? So as they embarked on this rehabilitative journey, they excluded, Black children. It was decades later when it took a turn to becoming more punitive. It just so happened to coincide with more Black kids being welcomed into juvenile court, and I'll let you put two and two together there. But if that's the history of the development of law and policy around it, it's clear why we see the outcomes that we do today.
Thank you all for your responses. And with that, we will hand it back over to the wonderful Law Journal. Right, okay.
I'd just like to propose one more round of applause for all of the distinguished panelists that presented today. On behalf of the Journal of Healthcare Law and Policy and the University of Maryland School of Social Work's Daniel Thursz Social Justice Lecture Series, we thank you for attending the law school portion of today's presentation and the three panels that we presented. We invite you, please, stretch, take a brief break, and then join us at the School of Social Work Auditorium for the final panel today, Where To? That'll be starting at approximately 5 p.m. If you do not know where that is, please, there are many members of the School of Social Work here. Grab a buddy. We will get you there. We invite you to join us in just a little bit. Thank you again for everyone being here.